on. Okay. So I've hit record. It is officially 9 o'clock, and I'm going to do my best to keep within the time structure so that way you guys don't have to hop off in the event that you guys have work or any of that good stuff. But again, if you guys do have to hop off, you won't hurt my feelings. Absolutely do so if you need to. But this is such a fun week. I love this week. I hope you guys have had a chance to look at the assignment for this week because it's a good one. So let me go ahead and show you this. Dr. Helgi and I designed this week to be fun because up to now you guys have absorbed a lot. Have you guys really just kind of taken a seat back and really thought about the amount of case law and concepts that we have, explored up to now? That's a lot. And especially last week, you guys had a very big assignment to tackle. And I know Dr. Helgi is still kind of working through some of those. So if you don't see a grade, that's why he's still working through, because again, y'all are a huge group, but have done really well this term. So again, keep doing what you're doing, take into consideration all of our suggestions, all that fun stuff. And I also want to say thank you. I reached out to a lot of you, I think about like maybe 2 weeks ago, and it was kind of funny because this is the first time I've done that. And I did it because last term, I got a really sweet email from a student who told me how it was their first time taking online courses and they really felt disconnected and they weren't really, you know, pumped about the online world. And so I thought about that and I thought, there's something to that. And I feel like even though we meet virtually like that, like this, it is weird, right? Because we're not in a classroom together. And I love my face-to-face classes and I love teaching you guys too, but it is different. And so I decided to email you guys again, I think about 2 weeks ago, and it was so funny and it was really cool, but also overwhelming because I sent those emails out. I took about 2 days to send them out. And within about a week and a half, guys, I'm not exaggerating. I had 215 email responses, and I was like, holy cow. At first, I was kind of panicking. So I was like, what did I get myself into? But on the other hand, I was like, you know what? This is good. I'm really pumped that you guys are taking the time out to respond to me, but two, I got some really good feedback from y'all in terms of how you're feeling. Some of you are like, I'm good, and that's awesome, and I was really pumped to hear that. But some of you were like, I do feel a little bit disconnected, but this helps, right? So I'm glad it helped. But in any event, if there is something that we can do to ramp up you not feeling disconnected, please let me know. So I just wanted to briefly tell you thank you for that because I really appreciated that. All right. So a few reminders before we dig in that Dr. Helgi and I wanted to give you a gently prod on, which is first and foremost, can you use outside cases? You all should collectively say what? Dun, dun, dun,
No,
dun. Good.
no.
Absolutely. No, we don't want to see outside cases. Now, this week apparently I didn't grade them. It was Dr. Helgi that graded this last week's assignment, but apparently there's quite a few that use outside cases. Now, guys, I know that it's tempting to use cases that you find using the Google, but don't. And the reason is there is a method to our madness in the cases that we choose for you guys. If we were just to say, find a case that supports your position. You'll find one. There's a million cases out there. But the trick is, what can you do with the tools that we give you? That really shows whether or not your analytical skills have been honed enough to demonstrate that you're becoming a legal scholar, right? Because again, you can find a case all day and night to support your position. But what really shows true legal analysis, legal scholarship, is when you can use a case with a concept that may not necessarily instantly look like it applies, but after reviewing it, after learning what it is and its context, then after that you can say, you know what, it does link, and this is how. That's the trick. That's what we want to see developing week by week by week. So again, try to stay within the, guardrails that we provide for you week to week. And I also want to convey that if you didn't do as well as you'd hoped, that's okay. Um, we don't expect, and let me make this a little smaller. We don't expect perfection 24/7, all right? So if you didn't do as well as you hoped, that's okay. This one assignment will not sink your ship. Um, but what I would emphasize is that if you didn't do as well as you had hoped, just take the feedback, learn from it, and do better, right? That's the key. Nobody is perfect from the start. Okay, now we do have a few unicorns, right, that from day one are just rocking. And that's great, but not everybody is a unicorn. And that is to be expected, right? It's a journey. So don't beat yourself up, give yourself some grace, and just live and learn from your mistakes and from our feedback. All right. So a little bit about the final exam. I've gotten some emails asking about what it is and what it's about. And I want to convey a couple things. This is actually my last office hour, live office hour, because we don't have anything new after this. This is it. Isn't that crazy? So our final is almost identical in terms of structure, not content, structure. Okay, structure. Like week 3 and 5. So it'll open on a Sunday, right? And it'll be a hypothetical. And guys, you can use anything, right? Here's the rainbow. Anything that we have covered throughout the entire term. So you have a beautiful buffet of cases to choose from. For all the way from, think about what we tackled week 1, all the way to what we're going to talk about today, right? For this week. So you can use any of it. So what I would suggest is, again, I really hope that you guys are keeping a running log of cases. Okay. And I want to ask you guys something because my face-to-face class this week asked me, because my constitutional law class, they're taking an exam on Friday, this Friday. And one of my students, Smarty Pants IT kiddo, asked me if I could create a chat bot to help them study. And I actually created one last night. And so I felt like pretty cool because I never created one. But I was blown away at how awesome it was, to be quite frank. So just I don't know if any of you have used one. Just out of curiosity, have any of you guys used a chatbot before to study? I'm curious. Anybody?
No, no.
Okay, so somebody said, what is a chatbot? I'm really glad you asked that because now I feel better. I felt like I needed my oatmeal and rocking in a rocking chair watching Wheel of Fortune. Because when my student asked me that, excuse me, I had the same reaction. I said, what is that and where would you even do that? And so and again, I don't want to take up too much time, but it helps, you go on ChatGPT. And what I did is I fed all my lecture notes into a closed system so it doesn't reach out into the internet and find information that could be wrong, right? Which happens a lot on ChatGPT. It hallucinates, right? It can give wrong information to the user because it is designed to please the user, right? So it'll tell the user a lot of times what they want to hear. But this only pulls from information I feed it. So I create a little robot, right? Chatbot, and I feed it my PowerPoints, my lecture notes, the study guide, all this fun stuff. And I tell it to help guide oh, cool. Caitlin said I did that to create condensed notes for each week. Oh, that's awesome. That is really cool. But I tell it to help the student study for, and for this case, it was a multiple choice exam, for a multiple choice exam based on blah. And so it actually quizzes the student, and if they get something wrong, it guides them as to how and why they got it wrong, which is beautiful. It was really cool. So I say all of that to ask you guys this. Would you guys like that option? And you don't have to use it, okay? I'm not saying you have to use it. You guys can ignore it 100%. But if I were to create one for this class, meaning I create a chatbot that tests y'all on your knowledge of the cases and on the concepts, would y'all like that? Okay. Okay,
For
cool.
the
Yes.
Hey. Okay, and like I said, y'all can ignore it. You just don't have to use it at all. It's not required at all. I was just excited because I learned how to use a new toy. So I was like, woo! I felt like a cool kid. And so I was I yeah, I had a cool kid moment yesterday. And that was after I, guys, spent 6 hours on Sunday because my South Texas kiddos had never had king cake. And I was like, I cannot, in good conscience, let them leave my class without giving them king cake the day before Fat Tuesday, because today is Fat Tuesday. So happy Mardi Gras, everybody. So I literally spent 6 hours on Sunday making three separate king cakes, one with nuts, one without, because I don't want to get sued for giving somebody a nut allergy. So anyway, so I did that and I learned about creating a chatbot. So it was a good day.
Was
So
that the baby?
yes. Oh, and I did put the baby in, but I warned them. I said there are, because I put three babies, one in each king cake I made. And I said there is a baby in one. And if you guys bite it, I said just be careful and don't sue me if you crack a tooth. So, but yes, they found they were super excited. It was cute because they know one of them had had a king cake before. So it was really cool. It was a neat experience to experience their first time having a king cake together.
Now they know that they have to supply it next time, right?
I did, well, I changed it a little bit. I did because and for instance, HEB down here doesn't sell the purple sugar sprinkle, so I had to make my own. So there's like some things that you can't find down here, or that are hard to find, I should say. So I told them instead that they're welcome to come to my house and learn how to make it because I'm always up for teaching people how to do things. But I told them instead that we'll go with they're going to have luck for a year. I thought that was a nicer way to do it because I don't think they're going to do that. That's why cheapskates just eat the baby. Yeah, that's funny. I like that. All right. So
In
that,
Mexico,
I'm sorry.
sorry, in Mexico they have something similar, and then the person who gets the baby has to bring the lunch for the next day.
Oh, see, it's kind of the same concept. Yeah, absolutely. So kind of the same thing. There's so much overlap in terms of some of these celebrations and cultural traditions. It's cool to learn about them. All right, guys. So before I go any further, does anybody have any questions about the final exam?
How long is it going to be, the writing assignment?
So it's untimed. It's just like your week 3 and week 5. You'll have an entire week to tackle it.
But how long do we have to write? Like is it how many pages do we have to do?
Oh, I'm sorry. I'm sorry. I don't think I can just, let me see. I might have, no, I didn't disclose that. I don't think I can disclose that yet. So I'm gonna have to, I don't think I'm permitted to tell y'all that as of right now. But it is, like I said, it's very similar. It's more, will say it's more closely aligned to your week 5. I can say that without getting in trouble.
All right, thank
Yeah, absolutely. Sorry, I can't be more specific. Um, but yeah, I would think of your week 5 assignment and know that's very, very similar. So this week you have a really fun assignment, and I want to emphasize that there is a word limit, and two, that if you don't like any of these movies, you can pick another one. Just let Dr. Helgi and I know which one that you would like to do instead. Okay. But these are pretty good choices. My Cousin Vinny is always my favorite. I love that movie. I could watch, that's the kind of movie I feel like you can watch again and again and still laugh, or at least I can. I always think it's funny. But great movies. So, but if none of these are your cup of tea, you can absolutely pick a different one. Okay, just let us know beforehand. Let's see. Carla said the exam says it's locked until February 25th, which is a Wednesday. They might have extended it this time. Let me check with that Dr. Helgi on that, Carla, or that might have been a mistake. But I will double check on that and I'll let everybody know in the announcements. I'll make sure that's confirmed. And then Say said 12 Angry Men is good for an old movie. Yeah, absolutely. Yeah, there's some great movies in here. So just go through the list and Double Jeopardy, Howard Bundy. I don't know about the movie Double Jeopardy, but send us. Oh, that's what one thing I was gonna say. If you are going to ask for a movie that's not listed, send us a link of the trailer. Because there's so many movies out there, and I'm kind of a movie nut, and I've watched a lot of movies, but I haven't by any means watched every movie. So make sure that when you ask Dr. Helgi and I, and loop us both in, send us a link to, a YouTube trailer of the movie. So that way we can watch it and make sure that it's kind of on par for this assignment. Billy asked TV shows. Maybe TV shows, If there's a specific episode, I will say that if there's a specific episode. So if there's a specific episode you want to dissect, that would probably be best, Billy. Does that make sense? Now I know which Double Jeopardy you're talking about. Thank you, Dan. You said Ashley Judd. Now that brings a bell. That was a great movie. And Better Call Saul is fantastic. Yes, that would be great. But yeah, just pick a specific episode so we know which one you're specifically dissecting. And that's a great show to dissect. So, with that being said, now that you kind of have in mind what you're tasked to do for this week, um, there's a couple of things to note. I want you to remember it has to be a law-related movie. We had a couple of incidents in the past in which somebody tackled a movie that had nothing to do with law. So there's a lot of great movies out there, but just remember it has to deal with law in some way, shape, or form. Okay. Um, so Dark Waters, I don't recognize that one. So yeah, just send us a link and we'll review it and see if it jives with the assignment. But when you tackle it, you're going to want to spot and describe a scene or scenes within the film, and excuse the typo, in which any of the following was violated. Are you guys ready? So you can spot if there's an equal protection issue, if there was a constitutionally protected right that was violated, if there's a substantive due process right. Now pause. You guys yell at me nicely or put it in the chat. What are some examples of a substantive due process right?
The right to marriage.
Good. Right to marriage. Absolutely.
Right to a speedy
marriage.
trial.
I'm sorry.
Right to a speedy trial.
Good. Your Sixth Amendment right to a speedy trial. Brian said Miranda rights, right to vote. Good. Okay, you guys are all on the right track. So those are things to look for. Privacy issue. So a good example is, and this always makes me laugh, the movie Bad Boys, which I always used to love those movies, but there are certain scenes in those movies, and I don't want to give it away if you guys are going to tackle those movies, but do they have search warrants? Just throwing that out there. That's something to look for, right? And we'll go into that a little bit today too. And then in large part for today in particular, if you're going over like a police type of movie or TV show, look to how they interrogate their search and seizure procedures, their stop and frisk procedures. And again, we'll go over that today. Are they done properly, right? But that brings me to a very important thing. Be sure to explain, and let me move my head as I say this. Be sure to explain why you think the right was violated. But also, if you can't find anything wrong, because there are some movies in which they actually do things right. If there wasn't a violation, also explain why. It doesn't always have to be what they did wrong. You can also highlight what they did right. So again, you can look at both sides of the coin when you're dissecting your movie, okay? So let me go to the chat because I see a bunch of people responded. Let's see. Dark Waters deals with DuPont Corporation, forever chemicals, and toxic waste dumping in the water, source of a small town. Oh, yeah, that would be a great one. Absolutely, because that sounds very much like a civil matter. And oh my gosh, oh, how cool! There's a picture in the chat. I know for those who are watching the recording, you don't see the chat, but Michael just posted a video of him with from a place in My Cousin Vinny. That is so cool. Dan said enemy of the state. And then in Bad Boys, no, and they return to full duty after police shooting and skip the 6 months of administrative duty that real police must endure. Yes, yes. So if you guys want to dissect Bad Boys, that one is a treasure trove of just not reality, right? So I'll just put it that way. You will not have any problem finding violations in any of the Bad Boy movies. So fun to watch, but not realistic. But the other thing I want to highlight is when you're dissecting it, guys, make sure you're using case law, okay? You can use the Constitution, refer to the articles, all the fun stuff that we have explored throughout the term, okay? So just make sure that's in there. I don't want to see you say something like, I believe that there's a violation because they violated the Sixth Amendment. Okay, well, that's great, but why? And is there a case you can, hang your hat on when you say something like that? So make sure that there's a strong foundation for these type of statements. And you have 400 words. With that being said, if you're a little bit over, that's okay. If you're like at 420, 425, whatever it is, we're not going to ding you for that. But I will say, if you stop yourself at like 200 words, you're shooting yourself in the foot. So that was one thing Dr. Helge did note to me when we talked last, is that some of you cut yourself really short in your writing assignments. I will say we prefer students go a little over than way under. Okay. So it's good to be concise, but don't be so concise that you're basically giving us a skeleton worth of analysis. All right. We want it to be fleshed out a little bit, right? So make sure that you don't cut yourself too short. And let's see. Elaine said, I emailed yesterday. Oh, Elaine, you're fine. I know exactly the movie you're talking about. So you're good. So no need to send the link. I know exactly which one you're talking about. Oh, Dan said, I did cut myself short. I stopped at 399 words. You're fine. Okay. But I want to emphasize your classmate responses do not have to be 400 words. Although if you want to go that far, you absolutely can. It's up to you. So if you want to write War and Peace to your classmate, go for it. All right, so before I go any further, do y'all have any questions about the assignment for this week? Which I think will be really fun. I feel like this is the week that you guys can kind of just let loose and watch something fun and dissect it with your legal lens on and kind of just, have fun with it. I feel like it's not as stressful this week, or at least I hope you don't feel like it is. Okay. All right, guys. So this week, I love this week. Real quick question. Carla said, so there are 2 assignments for this week. Write the paper and 2, respond to a classmate's paper. Is that accurate? I'm not sure. No, it's just it's write the paper. No, it's just for the movie this week.
So is it a paper or is it a post?
Oh, no, well, it's
Post with 2 replies?
it's your initial post, right? And then your replies. But it's not paper, so to speak. It's not as okay, let me put it this way. It's not as formal as your week 3 and week 5. So it's just a longer post. Does that make sense?
Yes, thank you.
Yeah, absolutely. Okay. Any other questions? If there is, you can cut me off. All right, so I'm going to slowly talk about what is in store for this week because you have some really great cases. Now, this week in particular, you have some heavy hitter cases, especially for law enforcement. Now, I love these cases because in large part, in addition to teaching you guys and teaching undergrads, I help consult on the side for training officers, especially for CCPD. And I love it. But these are primarily my jam. I love these cases. I love training with these cases. In large part because no case, and I said this the first time we met, and so I'm curious if you guys remember this, but no case makes it all the way to the United States Supreme Court because it's boring. There's humans involved. And guys, you all know people are cuckoo. And not only are people cuckoo, but we're complex creatures. And so these cases, like many cases, involve really fascinating backdrops. So I'm going to flesh them out. We're going to talk about the standards that they create. And I'm going to talk to you about how you can dissect your movies, especially if you're evaluating one that deals with law enforcement, like Bad Boys. And then if you guys have any questions, of course, let me know. But before I talk about Cats, I cannot just dive into it because Cats was preceded by history, and history matters. So I want you guys to finish this statement. Every man's home is his. What is the rest of that statement?
Castle.
Bingo, castle. Now, this statement, this perception is so important, fundamental to our Constitution and to our culture that think about this. There have been studies done about how close Americans stand to one another in comparison to other cultures. Now, how many of you have ever been to Germany? And I know some of you have.
I have a few times.
Okay. So how do people stand next to one another in Germany? Do they stand close or do they stand far away?
They have a little bit more of a distance.
And then when they talk to you though, like if you're talking to somebody in Germany, did you feel like they talked to you closely or were they further away?
They were a little bit further.
I heard a
They
couple
would step
answers.
in.
It depends on the person.
It depends on the person, that's true, but in large part, in general.
If you're not with family, then yes, they're apart. They're
Okay.
at distance. But
Okay,
if you're
good.
with family, it's close.
Okay, excellent. And then what about how many of you have been to Italy?
I'm going this week in 4 months.
Oh, nice. Okay, cool. Have you been there before?
No,
Okay, so has anybody else been before?
I've been there.
Okay, and did you notice anything different in relation to how people stand next to one another or talk to one another in Italy compared to Germany?
They're closer.
Mm-hmm. Much closer. I always had to giggle. Old Rome is amazing. I always had to giggle when we had clients from Italy compared to our German clients, because our German clients would stand kind of at a distance. Whereas our Italian clients were what I call close talkers. And you guys know what I'm talking about, where they talk so close that you're just like, oh, you're invading my personal bubble, right? Because everybody has a bubble. And if you get too close and you invade your bubble, you instantly kind of feel like, ah, right? But culturally, every culture has an expectation of privacy in terms of distance. And there have been studies done to actually measure culturally that expectation of distance. Anybody know what Americans expect in terms of distance when we talk to strangers? Any guesses? I see a guess. 2 feet. No, much further. We're almost on par with Germans, but we're not quite as extreme. And Caitlin
far
said, I
enough.
like the 6 feet rule. Almost. So we maintain, if it's a stranger, like let's say you go to HEB and you're standing on an aisle and somebody's coming up to you and you want to go see something that somebody else is looking at, but you don't want to invade their space. Typically, studies show that Americans give each other 3 to 5 feet. And if you think about it, that's pretty on par. Think about that or look at that when you go to the grocery next time or you go someplace in public next time. You'll see that people typically give each other that much space. But that differs if you're friends. If you're friends, it's about 2 to 3 feet. If you're family, it's closer, it's about 1 foot. So again, but culturally, Germans, they give, again, strangers, if they don't know the person, they're at a store, they give each other 6 to 8 feet. So they're like, get the hell away. Whereas Italians, this is kind of funny, stranger wise, 1 to 3 feet. So they're like, come closer. So we have a much greater expectation of privacy than the average bear. And that's written into and expected within our Constitution, within the Fourth Amendment, and within our case law. And just this very statement, when I said every man's home is his, I bet all of you instantly thought this. I would be surprised if any of you were like, I don't know how this ends, right? Now, with that being said, I want you guys to look at the Fourth Amendment. Now, the Fourth Amendment uses this beautiful verbiage, and it says that essentially all of us have the right to be free of the government coming into our home, right? Taking our stuff. And if they do, that's considered unreasonable. Unreasonable searches and seizures, unless they have a warrant. So this is the guidebook. This actually gives the instructions on how to play the game in order to invade somebody's personal space if you're a government actor. Now, with that being said, the million-dollar question you should be asking is, well, what is unreasonable and what constitutes a search? because this doesn't define it. The founders were pretty bad about that, weren't they? They didn't define a lot of stuff. Who did they leave that up to? Supreme Court, right? So, with that being said, after looking at these two questions, this is the guiding theme for the case law that we'll look at first, okay, with the Katz decision. But before Katz, the Supreme Court did not look at warrants in any way, shape, or form the way we look at it today. All they focused on was physical intrusion, meaning in Olmstead versus United States, it's 1928. So what was the government obsessed with in 1928? It was always one of two things. Any guesses?
Communism or alcohol?
Good. Yeah. Prohibition. Yeah. Alcohol. The party stopped. No more fun. So in Olmstead versus the United States, they suspected, and this is an actual photo, that the individuals in the apartment above that basement, so they're in the basement, they suspected the people above that basement were involved in bootlegging. But here's the kicker. Can you get a warrant based on suspicion? Nope. What do you have to have? What did the Fourth Amendment say you had to have? And I'll go back to it, in order to get a warrant. And it tells you.
Probable cause.
Probable cause. So that bar is up here. Probable cause is facts or information that a crime has been or is being committed. Now note that certainty. It's not maybe, might be, it's has been or is. You have to be pretty darn sure in order to get that piece of paper that allows you to walk into a person's privacy, invade it in order to confirm what you have submitted to a judge to say, look, we have all this information that a crime has been or is being committed. So with that being said, they didn't have that. And so what they did without a warrant was they went to the basement and they wiretapped everything that was going on in the apartment above them. Now, what are they not doing? They're not entering into that apartment. They never stepped a toe into that person's apartment. So they were able to record everything. And unfortunately, slash fortunately, everything that they suspected was right. That person was hands down just in a major operation of bootlegging. So that person was convicted based on that. And that person appealed and said, wait a minute, that's not right. They shouldn't be able to wiretap my home without a warrant. But the Supreme Court said, no, that's actually quite all right. There was no Fourth Amendment violation because there was no physical intrusion by the officers into your home. Isn't that cuckoo? So at that time, the Supreme Court only focused on whether or not there was a physical intrusion into the person's home in order to require a search warrant. So that opened a really interesting door for law enforcement to take advantage of. Same thing with, let me move my face so you guys can see this. Same thing with Goldman versus United States. They put a listening device on a wall of, and let me actually, I lied. Let me show my face real quick. Oh, darn it. Hold on. Here we go. I'll show my face only to show you this. So hold on. Can y'all see my chair? Here we go. Can y'all actually, I'll just do this. So pretend this side is an apartment and they want to know what's going on in this side of the apartment, but they don't have a warrant. So they go into this apartment, which is empty, and they put a listening device on the wall and they hear everything that's going on in this apartment. Now, again, they don't have a search warrant because they didn't have probable cause. But what are they not doing to this apartment? And think of Olmstead, I'm sorry.
Physically going in.
Bingo, Billy. They never physically entered into this apartment. They, the whole time, were over here. There was no physical intrusion. So even in Goldman, they confirmed that that type of search was a-okay. There's no violation because there's no physical search. So you see time and time again, and by the way, they use this device, which I will be so impressed if you guys know the name of this device. And I've been looking for one in antique stores forever, and I have yet to find one, but that's my goal. So y'all know what it's called? It's the best name. Are y'all ready? It is called dun 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 Detectaphone. Isn't that great? I always think this sounds like a very like Hardy Boys, Sherlock Holmes-ish kind of name. I just love it. But nonetheless, it was considered 100% okay. So you see time and time again that they're confirming that that's okay. And they did the same thing later. I'm glad you got a kick out of it too. They did the same thing in Silverman, where they said the only reason why this was considered a violative search and that they should have had a search warrant is because the officers went through this apartment, so on this side, and there was a heating duct, and they took what's called a spike mic, which looks exactly like you would kind of suspect it would be, and they shimmied up here to this heating duct, and they shot it through. So now what has happened?
They actually
Now-
violated the space.
Good, Dan. Yes, now they've actually violated the space. There's been physical intrusion, right? So you see that they're just confirming again and again and again that if officers physically penetrate somebody's living space, then that is the green light for you should have had a search warrant. But then that opened that door to officers saying, well, as long as we don't physically enter into their living space, then we can search all day and night and we don't need a search warrant. So all of these cases focus on the physical intrusion into the defendant's property. So I'm setting the stage. The reason why I think it's important to emphasize that is because cats, guys, blew the lid off of what law enforcement had been doing for decades. Now, this is 1967. This is the Warren Court. The Warren Court, I mean, it's kind of like, and this is dated, but you know, like Oprah was like, you get a car, you get a car, you get a car. The Warren Court was like that with rights and with limitations on law enforcement. So they were like, you get rights, you get rights, you get rights. And, you know, you're limited, you're limited, you're limited. The Warren Court was that explosion. So it's 2026. This is still the test for search warrants. Likewise, when we go over stop and frisk, that was the Warren Court too. So this court was very busy for this time period. So I just kind of want to highlight that as you read the opinion, I want you to kind of note that. But I want to highlight also, I'm not rooting for cats, but at the same time, you got to be impressed with this guy because it's 1967 when it reached the Supreme Court, right? But he was doing this international gambling operation like a bookie. He was a bookie for horse races, dog races in the early 1950s. So, I mean, you kind of have to give him props. He was kind of like an entrepreneur and he was very successful at what he did. So the feds were onto him, but they didn't have probable cause. They just had reasonable suspicion, and you can't get a search warrant based on reasonable suspicions. Not enough. So they noticed that good old Katz, you know, again, he's a businessman through and through, and he went to the same telephone booth every day at the same time. So, you know, he would show up to work quite consistently. So he'd go to the phone booth every day, same time, conduct his operations. But again, they weren't sure, but they highly suspected because they had certain informants that were saying, you know, his name, we've talked to him, he takes our book, you know, our gambling, blah, 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 blah. But again, they weren't sure. So this is what they did. Right before he shows up, they wiretap the phone booth. Now, does he live there? Anybody?
No.
No, it's a public place.
Good. It's a public place. So he doesn't live there. It's a public place. And so for all intents and purposes, based on Olmstead, based on the Clinton case, based on the Silverman case I just showed you, based on all of those, they're like, we're good. We're not doing anything wrong. So, you know, Katz goes in there and he's with his booking operation. He makes his calls and they're recording everything without a search warrant. And they confirm that they are 100% right. He is a busy dude. Like he is like making operations and taking calls and bets from not just all over the United States, but from other parts of the world as well. Like he is a busy guy. And so they arrest him. He's convicted. and he goes to prison. But he sues and appeals his conviction because he argues they're recording my conversation. That's a no-no. They should have had a search warrant. But based on prior case law, everybody thought this was a losing case. Well, of course he would lose because based on everything that the Supreme Court had done up till now, they never entered his personal space, right? There's no physical intrusion. However, the Warren Court came out with a doozy. They created a two-part test, which is still alive and well. The two-part test says, ask, does the person have a reasonable expectation of privacy, and is it one the society agrees with? In other words, when Katz got into that phone booth, what is the first thing that you think he did when he entered that phone booth?
Close the door behind him.
Bingo! He closed the door. So he gets in there and he closes the door. Why? Why do you think he closed the door?
For privacy.
Bingo. He wanted privacy. You don't want to leave it open. And even if he wasn't doing illegal stuff, you would typically, even today, close your door or show the world in some way, shape, or form that you have an expectation of privacy. So the first question, do you have an expectation of privacy? Check. Yeah, absolutely he does. And would society agree with him? Absolutely. So because it's yes and yes, the answer is they should have gotten a search warrant. So no longer, and I mean, think about this. This blew the lid off of what law enforcement had been doing again for decades. And instead, now you're focusing on an expectation. You're no longer focusing on physical intrusion. You're focusing on a person's expectation of privacy. This is a big deal, right? Huge deal. So now, as of 2026, this is still the test. So I'm looking at your chats. Okay, good notes in chats, guys. So as of 2026, you guys will focus on this in order to determine whether or not a search warrant is needed. If the answer is yes to both, you have a search for Fourth Amendment purposes. So let's look at some examples. Okay, so I know this is dated because, you know, the cell phones are quite old, right? The guy has like the old school mic. I need to update this image. But nonetheless, the idea is still the same. You're in an elevator and let's pretend I'm going to pick on, let's say this guy in the back. Let's say he is an officer because it has to be a state actor or a government actor. None of this applies to you and me, right? This only applies to government actors. So let's imagine this guy is a law enforcement officer in plain clothes. And this guy right here, let's imagine, let's see, what is he talking about that's illegal? Let's make something up. Somebody give me something good. What crime is he talking about openly?
We're gonna rob a bank.
Yes, he's gonna rob a bank, and he's saying, yeah, the one on so-and-so street's a good one, and he's just rattling on. Does he have a reasonable expectation of privacy in what he's saying on that phone?
Nope.
No, not at all. Is it one that society agree with? Nope. So would that officer need a search warrant in order just to go boop and record and that's what a recording sounds like, guys. Boop. Would they need a search warrant to record that?
No.
No, absolutely not. So that's the two-part test. Same thing for this. I always laugh at this, by the way, because I don't know if you guys have walked around like a college campus lately, but it's very weird. And I say that because, or it's really everywhere, I guess, but in particular, I feel like it's college campuses because now everybody like uses their speakerphone. Like they don't just like talk, it's like on speaker and you can hear everything they say. And I became really invested in one student because I decided I would like get my steps in. So I parked extra far away from my building. And she would walk in front of me almost every day. And this sweet student, I could hear everything she was saying to her friend. And she would talk about her boyfriend, who was, for all intents and purposes, he sounded like a terrible person. And after an entire semester, this is last year, I would listen to this and I was like, oh my gosh, just leave him. Like I became so invested in this sweet girl. I was like, oh my gosh, it's terrible. But does she have a reasonable expectation of privacy and what they're saying on the phone in public like this? No. And it's not one that society would agree with either. So what about this? Now, this is a little bit different. You get in your car, you're on your phone, or now it's Bluetooth. Most people have Bluetooth in their car. Not everybody, but a lot of people, right? So you get in your car, you turn on your call, you say, Siri, call so and they call so and so in your car, and you're having a conversation in your car. If an officer's walking by and they hear you having a conversation in your car, and maybe you're talking about selling meth, right? I don't know. It's a big weekend. And they go boop again, hitting that record. Can they do that without a warrant? I'll go to the chats. Okay, good. Y'all are all saying no, but why? You're right, but why?
Because you're inside your car where you close the door.
Bingo! Yes! And what is that like? It's like the 2026 version of what?
For the phone booth.
That's exactly right. I always say it's like the 2026 version of the phone booth, because the first thing that Katz did when he got in there was he closed that door of the phone booth, showing the world, I expect privacy. That's the same thing you're doing when you're in your car. You get in your car and you typically close that door. Now, I
But if you
always
use
get
the
this
Bluetooth-
question. I'm sorry?
But if you use the Bluetooth, you can hear the people outside.
And that's what I was gonna. You read my mind. It's on a case by case basis, because I think all of us, maybe you're that person, right? But everybody at some point in time has walked by somebody's car in which their Bluetooth is so loud that you can hear everything they're saying. I would argue, and there's not a case yet that's gone up before the Supreme Court that has tested this, but, and again, this is not my personal opinion, I'm just saying, on a case by case basis, I would say that would be arguable. That if somebody's walking by and they're saying, I'm going to commit murder, blah, 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 and an officer hears that, I think there could be, that's the key word, could be a case for that. Because would a person have a reasonable expectation of privacy if their Bluetooth is on volume 50 and everybody, including the people in the store, can hear you? Would you have a reasonable expectation of privacy? Probably not. Would society agree with you? Probably not. So again, it is on a case by case basis. It's not just a blanket protection. It is case by case dependent. So that is why oftentimes a judge will determine whether or not a search warrant is or is not required.
Depends on if it's harm to somebody, then yes, they can go for it.
Good. And then what if they blast the speakers and they can hear it and the officer is in place, he's allowed to be? Exactly. That's exactly like the example I just gave. So you guys are on the ball. Then that guy just gave up his right to privacy. Exactly my thoughts. Yeah. Again, if it's on a case by case basis. So yeah, if somebody has, and I just went to HEB last week and somebody was fighting with somebody on their phone and I could hear everything. And it's so awkward, isn't it? It's like you're trying to put up your groceries and it's like awkward. But if that is the case, if you can hear everything, then no, you don't have a reasonable expectation of privacy, right? Again, indicating that's on a case by case basis. But in general, you would go through that two-part test. Does the person have a reasonable expectation of privacy based on the details of that event? And is it one that society would agree with? That's the two-part test, as per Katz, that is still alive and well today. Does that make sense? It's kind of fun. Yeah, waiting rooms is the worst, Caitlin. I'm with you. It's so awkward. And then so he said, that's probably what those FBI agents were thinking at the time based on case law. Yeah, exactly. Exactly. And then it just changed overnight. All right, so now we're shifting gears a little bit. So we're still in the world of CJ, criminal justice procedure, and we're going to talk about Miranda. I find it fascinating what becomes foundational in our society. And by that, I mean, it was so funny. The other night, I was with my son, and he's 10, and all his little friends, and they were, with Boy Scouts. And I asked them, I said, hey guys, can you finish this statement? I said, you have the right to, and all of them were like, the right to remain silent. And, they finished it off, and I was like, oh my gosh, they're 10. And they instantly knew that. Isn't that amazing? That even at that young of an age, we all have been exposed to this case and its consequences to a point that now, and I'm not saying we take it for granted, but it's like what's a good word? It's become just a part and parcel to our discourse, right? And expectation, what's there, right? So it's just really fascinating. But at the time of Miranda, of course, it wasn't a thing. And yes, I'm going to get into that. We're not rooting. Oh, that's so funny, Billy. We're definitely not rooting for Miranda, and I'll go into that and it's funny, I just taught this same case to my class yesterday, and I told them that the word of the day in regards to him was turd, because he was a turd. He was a terrible person. So nobody's rooting for Miranda. And I hope for many of you guys, you'll understand why pretty quickly if you don't know the facts of this case. So it all broke open when this young girl, 18 years old, she's raped. And afterwards, she tells her brother initially about the incident. And she tells him, it's rare when somebody who's gone through such a traumatic event can give such great detail, but she gives him amazing detail to the point that her brother says instantly, I know exactly who you're talking about. You're talking about Ernesto Miranda, because she was able to describe the van, what he looked like, everything. So they call the police, and Miranda, yes, he did. They bring him in and they put him in a lineup. And even on the lineup, without hesitation, she says, that's the guy, right? So from that point, they bring him into the room for interrogation. Now, when they put him in the room for interrogation, they don't, because again, it's not a requirement at that point. And I want to emphasize that it's not a requirement at that point. They don't tell him he has the right to remain silent. They don't tell him he has the right to an attorney, none of that. So they interrogate him for 2 hours, and he eventually confesses that he did it. And not only that, but he also he confirms in writing all the details that occurred with that incident and signs it. So he confirms, yes, I did it. I did it verbally, and he writes it confirming that he did it, right? So he is convicted, he's sentenced, so goodbye, Miranda, right? So you would think that's it. And let me hide my face so you can see the rest of these facts. Oh, it's so annoying when this thing does this. Hold on. Sorry about that. Just trying to hide. There we go. Okay, sorry about that. So he's sentenced to 30 years, but that's not, of course, where it stops. Now, here comes Warren again. Now, you guys know Warren because Warren was the decider in Katz. So you guys should already know that when you see Warren, you should know that Warren typically leaned, shockingly, toward providing more rights toward the people and more limits on the government. Which, again, and I'm going to test y'all, who did we talk about at the beginning of the semester that I told you that when you saw his name, you should instantly think of Arnold Schwarzenegger because they're going to beef up, again, I'm sorry for the terrible impression, but beef up the federal government. Do y'all remember? Nobody remembers?
It was the one that
Thomas
presided
Jefferson.
over Marbury versus Madison.
So Marshall,
Marshall.
right? Yes, Marshall. Y'all have not had enough coffee. I've had a lot. So I'm like, woo! So it was definitely Marshall. So I want you to kind of think of Warren in that capacity, because what is interesting about Warren, the reason why I'm going to go into what I'm about to go into, is I think it's important to highlight that our justices are human, and that as human, and Sandra Day O'Connor made this beautiful statement one time, and I thought it was so important to recognize. She said, it isn't possible to walk through the courthouse doors and make yourself devoid of all personality, all human experience. And I think that's very true. They are who they are, right? And so with that being said, a lot of our justices have surprised us, and they don't always rule the way in which we think they will. And Justice Roberts in particular is a perfect example of that. He's thrown many surprises out there that have shocked legal scholars and society at large, right? So again, they don't always go the way you think they're going to go. But Warren in particular was a shock. because his background indicated that he was going to rule in the government's favor because he, in fact, was appointed by Eisenhower. And, a Republican president, Eisenhower appointed him. He was a state prosecutor. And for those of you who kind of know the characteristics or the personalities of prosecutors, they're very law and order, right? And in fact, what's fascinating is that when he ran to be governor of California, his platform was law and order. So everybody, when this case came forward, thought that, oh, well, he's going to go in favor of the state. He's not going to go in favor of Miranda. Nobody thought he was going to go in favor of Miranda. And I want to emphasize that because it just, I think historically, contextually, it's really fascinating, right? Now somebody said that's why President Light considered Warren the biggest mistake of his presidency, the biggest damn fool mistake ever made. Yeah, it's interesting. The same thing was said of Justice Roberts when he was appointed. They thought he was going to make all these decisions on a very conservative spectrum, and by conservative I don't mean Republican, Democrat, on the conservative side. And then he's made many decisions that have surprised many. So you don't always know how they're going to rule. So it's just really interesting. But neither here nor there. So Warren, after that, Miranda argued that per the 14th Amendment, that the federal government would, because of selective incorporation, gather those rights, especially the Fifth and Sixth Amendment right, and apply it to the states protecting him. Now pause. Do y'all remember what selective incorporation is? What does selective incorporation allow the government to do, allow the courts, the Supreme Court to do using the 14th Amendment? So just as a refresher, before I go any further, because I don't want to roll over like statements like that, selective incorporation is taking into consideration the fact that the original Bill of Rights did not apply to states. Remember, the founders were obsessed with federal action. They didn't want another monarchy. They didn't want it to turn into the executive becoming another king. Remember, George Washington said he turned down being king because he said, I didn't just beat King George III to become King George I. So they were obsessed with federal action. The 14th Amendment added those two beautiful words to the Due Process Clause. It said, no state shall take away a person's life, liberty, or property without due process of law. Meaning, it's like a leash. And it allowed them to leash the states, saying, you Texas, you Arizona, you whatever state it is, you too cannot violate a person's right. This amendment applies to you too. So it's a leash on the states that pulls them into compliance, right? That's what selective incorporation is. It allows the Supreme Court to rope in the states and apply a right on the states that initially didn't apply to them, right? So with that being said, what Miranda's arguing is that Fifth and Sixth Amendment right, the right to shut up, because you have the right to not incriminate yourself, and the right to an attorney did not apply to him. He wasn't told that. And as a result, let me move this, that not telling him his rights violated his rights, and that needed to be incorporated as a result, even though it was nowhere in the Constitution. But you guys know that just because something's not in the Constitution doesn't mean it doesn't exist. That's something you guys should have down pat now, right? But here's the cool thing. The Supreme Court always asks, and this should be burned into your heads, they always look first to, have we done it before? Meaning, has this been a thing before? And they said, actually, yeah, this isn't anything new. In fact, the FBI and the military, they were actually already doing this. anytime that somebody wasn't free to leave, anytime somebody was being interrogated by the FBI or the military, they would tell them that they had the right to remain silent and that they had the right to an attorney if they couldn't afford one, and that anything they said could be used against them within any type of hearing that was held against them, right? And those two environments. But now the court's saying, because it's been done before, we could do it. This isn't anything novel. We're not creating something new. We're actually just extending something that has been done and other platforms within our society. So ultimately, they held that the Fifth Amendment, of course, protects you from being a witness against yourself. The Sixth Amendment gives you the right to an attorney. And here, the argument was that Miranda didn't understand these rights. So as a result, he deserved a new trial. Now, when this happened, people freaked out. And I think you can understand initially why, because they argued, well, wait a minute, you're letting him go. Like, you just let a horrible person go. Because again, nobody's rooting for Miranda. But here's the kicker. No case, and I'm going to emphasize this, no case should solely depend on a confession, because that's what they kicked out, right? It was his confession that was his undoing. So they said, we're going to retry you, but we're going to kick out that confession. It's excluded because it wasn't obtained properly, right? So they kicked it out. But why should a case not depend solely on a confession? Any ideas?
Depending on how that confession was obtained. The methods
That's a
used.
biggie. Absolutely. That's a biggie. That's a biggie. And let me put it another way, and I'm going to take it one step further. When a crime occurs, and let's just say, take the Guthrie case, that sad, horrible case with Savannah Guthrie's mom. Since that's happened, how many people have called and confessed to that? A lot. So one of the issues with any type of big offenses is that when crimes occur, there's a lot of people that may confess to something they never did, right? Because there's a lot of mental illness out there too. In New Orleans, when there were crimes, we had a lot of incidents in which people would confess to something, and they'd confess to something every week, guys. Every week we'd get the same person that called and said that they would commit murder this week, and next week they would have committed this, and they'd commit that, and they never did any of it, right? So a trial should never depend solely on a confession, ever. And so they did retry him without that confession, and he was found still guilty, right? And he was sentenced. So the Miranda warning became law, and that's why today we have the Miranda warning. When they retried him, again, he was convicted without it, but he was ultimately paroled. Bummer, right? We're again not rooting for him. And Cook's out there. Yes, Dan. There's some cuckoo people out there. That is indeed true. All right.
But he did.
I'm sorry.
Eventually, he was killed in.
Well, wait, no,
I-
don't say it yet. Don't say it yet. Don't say it yet.
Okay,
I'm getting
okay.
there. Don't say it yet. Because that's the best part. Okay, so the best part, and I'm getting to that, is when he was paroled, he actually became autograph famous. And this is actually his autograph. And I will say, I actually was initially, let me move that. Let me move my face. Oh, darn it. I'm not having luck with moving my face today, guys. Sorry about that. This is actually his autograph. And people would actually, law enforcement in particular, would actually ask for his autograph. And you can still sometimes find, especially on eBay, bids for his actual autograph, which is a little disturbing, right? But nonetheless, he would actually get paid to give autographs as well. So yikes. But remember, what was my word of the day yesterday? Do y'all remember? Aw, y'all don't remember my word of the day? It was like the best word. Let's see if y'all. Yes, yes. Well, Billy, yes, turd, right? So he was a big turd, not a good guy. And so what ended up happening in Miranda is actually pretty good karma, I think. And again, it's dark, right? But nonetheless, he got into a bar fight and he lost. And as he's on the ground, he's dead, right? Because he got into fights all the time, always talking trash to people. and he just picked on the wrong guy who eventually stabbed him. He's on the ground, dead in a bar. The offender who stabbed him is standing there. Police come, and guess what they read to the person who just stabbed Miranda? His Miranda rights. Ba-dum-bum. I'm sorry, I shouldn't laugh, but that is pretty amazing, isn't it? So that was the end of Miranda. So again, word of the day, turd. I think it's very fitting. So that is that. Now, there is something I did want to bring up. Now, we talked about Dobbs, right? What's fascinating is that the very day that Dobbs came out, this decision came out, but nobody talked about it. And my CJ brain was like, bah! Like, why isn't anybody talking about this? Because it just blew my mind. And I want to preface, I'm not saying it was right or wrong. I don't have any horse in that game. But what I'm saying is that it was fascinating and nobody was talking about it. And again, it's understandable because Dobbs really is a huge decision, but so was this. So Vega v. Takeo, again, same day that Dobbs came out, and it held that a violation of the Miranda rules does not provide a basis for a Section 1983 claim. Okay, so it goes on to say Section 1983 provides a cause of action against any person acting under color of state law who subjects a person to the deprivation of any rights, privileges, or immunities, violation of the Constitution. So in other words, if an officer, like, let's say, and I don't want to give the Miranda officers because I don't think they're a good example, but let's say today, 2026, an officer brings somebody into an interrogation, doesn't read them the Miranda rights, doesn't give them a bathroom break, and keeps them for 6 hours, right? And the person finally breaks down and is like, I did it just to get the hell out of there, right? And they actually didn't do it. No longer can you sue under the bus. So Section 1983 is the bus that you use to sue that officer, or you used to. No longer can you do that. Now, the confession can still be kicked out. You can no longer use the confession. That's still the remedy, right? But you can no longer sue the officer that did the bad behavior, right? So that's no longer a thing. That's a huge thing. That's a huge deal. But again, nobody really talked about it. So that's something to note with Miranda as of today that has changed as of 2022. Now, Justices Kagan, Breyer, and Sotomayor, they were quite upset about this. And you guys can read their statement right there if you would so like. Now, this isn't one of the required readings, but I did want you to be up to date on where Miranda stood because it is really interesting. And again, not talked about, which is really interesting. But we did have one more case, and I lied. I said I'd be done, and it's 10:07. I'm sorry. I keep failing you guys, but there's just so much to talk about. But I promise this is the last case, and I will get it done, guys. So we have the ability to search somebody based on probable cause. And we have the ability for law enforcement to enter into your home based on, again, probable cause. But what happens if an officer doesn't have probable cause, but sees a bunch of red flags? We don't want that officer, for all intents and purposes, just to sit back and see what happens, right? Like, let's see how this plays out, right? We want officers to have somewhat of an ability to act. But what is the standard? Before the case that we're about to talk about, there was no standard. In fact, it was somewhat of the Wild West. In fact, going back to English common law, it allowed officers to do whatever they deemed best. There was absolutely no standard in place prior to the 1960s until this case, which is Terry. Now, again, seizures, probable cause, it's in there in the Fourth Amendment, plain as day. But again, what happens if, again, you see red flags, but they don't rise to the level of being probable cause? What can an officer do? Well, again, that brings us to Terry. So 1968 case. So you guys should instantly know we have a Warren Court decision. Now, what's cool about this Warren Court decision is it actually sides more with officers. It allows them to take proactive measures instead of limiting, right? So it gives them a little bit of wiggle room to make a proactive step in order to protect the public. based on the scenario of this case. So just to kind of lay out the facts of this case, because it's really interesting. And if we're in person, I'd make you guys act it out, which is always fun. But in Terry v. Ohio, we have Officer McFadden. Now, Officer McFadden, he was a veteran, guys. He had been there, done that. He had been officer for decades. Okay, so he had the experience for sure. And he had been looking at the same kind of shopping center again for decades. So he knew the typical shopping behavior. He knew the typical folks that were in the area. And he was sitting back one day and he noticed some very suspicious behavior. Specifically, he saw a group of men who were obviously together, but they weren't acting as if they were together. So, in other words, imagine that you have one guy who's walking by, but in the middle, there's a jewelry store. And he'd stop, he'd look in the jewelry store, but wouldn't go in. And then he'd go to the very end of the shopping block. And then another guy would follow in his same footsteps, look in the jewelry store, meet the guy at the end, and they talk. And then the third guy would do the exact same, and then talk. And then they went back and they would do the same thing. And they did the same thing 3 or 4 times. So for all intents and purposes, what do you think Officer McFadden thought was about to occur?
Thought they were a case in the joint. They're about to rob the place.
Absolutely. Oh, and it's important to note that they also kept on messing with their waistbands and they were wearing large coats. So messing with their waistbands, looking around very nervously, meeting at various points, looking only at this one jewelry store. So he thought that they were casing the place, right? So he didn't have probable cause though, because this is facts or information that a crime has been or is occurring. He didn't have that. So that didn't open that door that would allow him instant access to them. And I like how Caitlin says it's sus. Absolutely. So what he ended up doing was he came up to the men and he asked them to enter into the store. And he did not enter instantly into their pockets, but instead he patted them down. Boop, 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 boop. And that's what the sound it makes, guys. Boop, boop, boop. So he pats them down and he immediately identifies two out of the 3 had guns and they weren't supposed to. And so they're arrested and they're convicted. Now, the question was, did he have the right to do what he did? Because up until that point, Terry frisk didn't exist. This is Terry. So reasonable suspicion didn't exist. This is the first time in which the court is faced with answering whether or not an officer had the ability to proactively stop somebody and invade their privacy space, right? For all intents and purposes, and then enter into their pockets based on what they feel might be a weapon, right? The court ultimately said, yes, they absolutely do. And this is why. And this is the standard as of 2026. And this is my favorite standard because it sounds very Sherlock Holmes-ish. Reasonable suspicion is permitted if it's based on articulable facts, and I'm going to give an example of that here in a second, of ongoing, impending, or past criminal activity, and this is best, that criminal activity is afoot. Isn't that great? I love that phrase. But I say articulable facts because the officer can't just say, I had a hunch, or I thought they were up to no good. And I say that because I had an officer that I was defending in New Orleans that literally killed the case in 2 seconds because they was put on the stand. And I think he just got nervous, to be quite honest. But when he was on cross, they asked him why they stopped and frisked this young man. And he literally said, because he looked like he was up to no good. Is that articulable facts? No, absolutely not. So that stop and frisk was immediately deemed a no-no, right? It was not good. Articulable facts is something like, in this case, McFadden could have said, they were walking back and forth, adjusting their waist pants. They were looking around furtively. They were walking together, but not together. They were looking at one specific store, the jewelry store, but not entering it. They were meeting up at the end of the block. You see how it's all those details that when put together, the puzzle looks quite suspicious, right? And it supports that there may be ongoing criminal activity or impending criminal activity, or that criminal activity is afoot. Again, I just wanted to say that because it's just fun to say. But that's not all. It also has to be based on the officer's observations, their knowledge, their experience, and their training. It can't be based on a mere hunch. So for my officers, I often give them this. Because one, I just love it, but it's a good way to remember that your reasonable suspicion, again, has to be based on articulable facts that you can give detail about based on your observations, your knowledge, your experience, and your training. It can't just be, I had a bad feeling. And treachery is afoot. Oh, that's great. Yes. And Caitlin said, is there usually like a suggested number of facts or observations for reasonable suspicion? No, there's not, because it depends. You may have 10 set of facts that all together are really suspicious, or you may just have 2 that together are super suspicious. So it really is just case by case. So there's not like a magic number. It just really just depends on the circumstances. But great question. So Terry v. Ohio is what opened that door. Now, my son and I created this for you guys, and I actually created this with him 5 years ago. And what's funny is during COVID, during that whole debacle, he had heard me lecture so much about Terry v. Ohio that he helped me create the scene. So enjoy a Lego version of Terry v. Ohio, but you certainly do not have to watch it if you do not want to. The last thing I want to point out, and you guys don't have to include this if you don't want to, because it's not a required case, but I always get questions about the seizure aspect of search and seizure, is seizure is defined as an interference with somebody's possessory interest. So if an officer takes away something that interferes with a person's possessory interest without justification, without a warrant, then that is a no-no. So the case that I like to bring up is Maryland versus, and I say Mason, I think that's a Louisiana in me, but maybe Macon, but I like Mason. But anyway, shape or form, as a quick speed through of that case, officers suspected this man who ran an adult bookstore of also selling child pornography. And they heard that if somebody asked for the brown bag special, that he would give, supply this item. But they didn't have probable cause, so they couldn't get a warrant. So they dressed in plain clothes, they entered the public adult bookstore, and when they entered, they asked the man for a brown bag special. So he brings it out, and the top is stapled, right? And so they take it, they bring it to the counter, they pay for it. Okay, so what happens when you pay for it? Well, the owner gives the item, the person gives the money, and then they get a receipt in return, and they get the item. So what is the owner giving up? Their possessory interest. And so they open it up, and ding, 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 it was child pornography. So they were able to arrest the person. So in that case, the court found it was not a violation of, it was not a violative search because the owner didn't have a reasonable expectation of privacy and the officers coming into his public store. And that wasn't an expectation that society would agree with. And in terms of a seizure, they didn't interfere with his possessory interest because he gave it up when he accepted the money from the officers. So they were able to do both legally. So that's one thing I wanted to include just for your own peace of mind in regards to seizure. So it's search and seizure, and there's 2 different tests. So make sure that if you dissect your movie and you're looking at seizure, that you note that, because it's not the same test as search, which again, search is, does the person have a reasonable expectation of privacy? And is it one that society would agree with, right? So I think that is that. Whew, I just gave y'all like a speed through and I was 18 minutes over. So I was over. I'm sorry, guys. I tried. I like to talk. And let's see. I see in the chat, reasonable suspicion means a set of explainable facts and circumstances which lead an officer in light of this experience to conclude that a person possibly is involved in past, present, or future criminal activity. It's crazy how all people who know their rights today are thanks to actual real criminals who were almost all really breaking the law. Yeah, that's you're not wrong at all. And I'm glad you point out the experience part. It has to be based on articulable facts, based on the officer's observations, experience, training in order to support having reasonable suspicion. So right on. And yeah, it is crazy how a lot of it deals with people who and everyday discourse you would not be rooting for. So yeah, indeed. And I hope you all enjoyed the Miranda fact. Again, the more you know. City and Georgia rhymes. Oh, it rhymes with Bay. Oh man, see, Dan said it's Macon. Macon could be pronounced like the city in Georgia rhymes with bacon. I like May. Oh, see, I still like my pronunciation. Although I'm sure if somebody is actually from there, they probably murder me for saying it wrong. All right, guys. Any other questions or anything? Oh, see, I'm not even going to say that one because I will say this morning I had a back and forth because again, it's Mardi Gras, right? And so there's a couple of the other people at my kids' school who are from Louisiana. And so we had a big debate about how to pronounce. And actually, I'm going to put it in the chat to see how y'all pronounce it. And how do y'all pronounce those two things? I'm very curious.
Praline and pecan.
Okay, well, the first one, okay, interesting. So we always used to say praline and pecan, and today was praline, and then somebody said pecan, yeah. It was so I was like, no. It was funny. So it's I think language is such an interesting thing. You can always tell so much about like where a person's from and everything. It's so interesting. Dan said, my New Jersey cousins say pecan. Yeah, I'd never heard that until this last week. Somebody said that. I was like, what are you talking about? And they're like, in your pie. And I was like, oh my gosh. I was like, that's how you say it? Yeah, it's so funny. South Carolina, we say pecan. Yeah, it's so cool. I just think language is fascinating. It's so fun. But nonetheless, guys, so I am working from home today. So if you guys want to give me a call, I'll be here. I'm just gonna be riding away. So I'll actually do this. 7283241. There it is. So if you guys have any questions, you can text me, you can call me, you can send smoke signals, whatever floats your boat, whatever works. Send emails as well, because I finally got through the 200 and some odd emails that I got in response. That was so funny. I thought that was crazy. Yeah, that's exactly right. Southerners say pecan. Yep, New Englanders say pecan. Yeah, I didn't realize that until I was talking to folks and I heard the other way to say it. It was just so funny. As a funny thing, as a side, guys, I do have a funny story to tell y'all real quick, and y'all can hop off if you don't have time. But when I had a case in New York, and it was a maritime case, and it was so funny because the firm I was working at, they actually were worried about how my accent would fare in New York. And so they tried to get me to have a speech like I don't know what you call it, like a consult, I don't know what you'd say, not a consultant, but like a what do you call it? Yes, yeah, exactly, Caitlin, like a dialogue coach. And I refused. I was like, that is silly. I am not doing that. I was like, this is how I talk. Like that is absurd. And I was like very offended, right? And so yeah, apparently. And so we went to New York and I'm arguing before the court. And I actually threw in a bunch of like things just to get them because again, I was miffed that they were saying that, right? And at the end, it was so funny because we ended up winning. And afterwards, the judge had came up, and we were chatting. And the judge, the one thing he did say, he was like, "It is so fun to hear your accent," and da 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 da. And I just looked at my team members, and I was just like giving them the stare. I was like, "See," I was like, "I didn't have to change the way I talk." But it was so funny. I had a blast in New York. I loved it. I would never want to live there, but I absolutely loved it. And it was the week that they tore down Yankee Stadium, so I got to see it right before they tore it down. And I was just like, boo. But it was fun. But yeah, I did not take the dialogue coach. So silly. Yeah, I bet, Dan. I bet. Absolutely. Okay, my friends. Well, I had fun today. I hope you guys did too. Have fun with this exciting assignment. Dissect your chosen movie. Pick a good one. Pick one that you're going to have fun dissecting. And yeah, if you guys have any questions or anything, just let me know. Like I said, you can text, you can call, you can email, any of the above, I'm happy to chat. And yeah, I will talk to you guys soon. So I hope you guys have a great day and happy Mardi Gras. All right.
Thank you.
Bye.